Yeah, you're losing that one.
Good evening, everybody, or good afternoon.
Right, for the good. Some of it is that. We're just gonna adjust the volume so we can make sure we hear you.
I'm doing the same.
All right, John, can you talk to us again, just make sure the volume's okay?
Sure, I can hear you just fine. Are you able to hear me?
Perfect. And we just looked at late. Right on time. Okay. Oh. Thank you. All right, so we have a long council meeting, so we'll get right to business. We have a motion to approve the agenda.
Moved by Councillor Minnick, seconded by Councillor Newcomb, that the agenda for the special council meeting of June 16th, 2025 be adopted.
All in favor? Carried. Any declaration of pecuniary interest in general ones thereof? Seeing none, general items, and we'll start right off with strong mayor powers and training by John Mascarin. Now, John, what I'll do is just a roundtable. My name's Dave Ford, I'm the mayor of the town of Kapuskasing, and we'll go next and we'll just give our names.
Martin Dennison, councillor. Bruce Newton, councillor.
Emily LeBlanc, councillor.
New treasurer.
General manager of public works. Donald Bouchamp, fire department.
John Meadow, chief official and director of planning, come down.
Ken Minnick, councillor.
Melanie Breton, councillor.
So that's everybody in the room, and oh yeah, I'm just nice. I went around and I skipped the two most important, obviously.
Time to get met municipal clerk.
Oh, and Tammy Filio, administrative secretary.
And we also have Mr. Keith Parisi, and he's in the crowd, just in case I don't forget anybody else. All right, so the floor is yours now, John.
Thank you. Thank you very much, Mr. Mayor, members of council and staff for introducing. I'm John Mascarin. I'm a partner with Aird & Berlis in Toronto, and I have been doing a lot of work over the last 2 months and I guess about a week on strong mayor powers. A number of my municipalities had received strong mayor powers in the earlier iterations, or sorry, the earlier rollouts. So I have been working on it for a little bit, and I'm pleased that I was asked to come here today to your municipality, and I'm hoping that some of this will be informational to you. Mr. Mayor, members of council, I do have a PowerPoint presentation that I would like to run. I'll share my screen and run it from there. There are some natural breaks in it, and if it's all right with you, Mr. Mayor, and your fellow councilors, what I can do is I can take a pause at the end of what I think are sort of natural breaks in the presentation and stand down and just ask if there are any questions. The other way to work it is I can just plow right through and you can ask the questions at the end, but I would really hate it if you had a really good question that you wanted to ask and weren't weren't given the opportunity to ask the question. So I'm in your hands, whatever you would like to do.
Okay, I think that's a great idea. We'll hold off till those times that you want to pose the questions. That's fine.
Terrific. Okay, so if I could, I'm okay to share my screen.
Yeah.
Okay, just give me a moment, and I should have it all ready to go here. Please let me know if you have it. Oh, it looks like it came up on the screen. Strong mayor powers.
Yep.
And that is your municipality, Kapuskasing, right?
It is.
It is. Okay, good. We're good to go. So what I'm going to do, Council, is just before we get to the strong mayor powers, I'd really like to give you a little bit of an introduction, maybe a prologue in it, because I think it's important to know where we were at prior to May the 1st and who had this idea? Who had this crazy idea, and why? Why was it implemented? I think that context might be important for you, and might lead to some questions, or perhaps not. But I think it's important for context. So, by way of a quick introduction, we have the traditional local government democratic system for local governments here in Ontario that's been in place since pre-Confederation. So before Ontario was actually even Ontario, before the Constitution Act 1867 created the Dominion of Canada, we had the local system of governance here in Ontario. And by the way, throughout all of Canada, because the rest of the provinces in the common law jurisdictions, not Quebec, but the rest of the provinces emulated Ontario and Upper Canada in having what is called the weak mayor system. It's the historical or traditional system of local government throughout Canada, first put in place in Upper Canada back in 1849, when the first consolidated municipal statute was enacted, often referred to as the Baldwin Act, where the mayor was made the mayor, or the head of council was made the ostensible leader of the municipality, but made as a leader among equals, meaning that the mayor has just an equal slice of the decision-making pie like every other member of council. Even though the mayor's elected at large, the mayor is the spokesperson for the municipality, the mayor is the representative of the municipality provincially, internationally, and locally. The mayor only has a single vote on council and has very limited unilateral and executive authority. In almost all cases, it's majority rules, and a majority of a council vote will get you where you want to go in local government. So you can see, taking away the complete suspense, what I really think of the strong mayor powers. You can tell by the title of this article. It was written while Bill 3, the Strong Mayors Building Homes Act, was being promulgated. It was being worked through. My colleague and I wrote this paper, this published paper, and we wrote, the role of the mayor has traditionally been viewed as a consensus builder, one where the head of council must work together in a spirit of cooperation and compromise in order to work with the other elected representatives of the municipality, i.e., the other elected members of council, in order to achieve a desired result. That has been the system that has been put in place in Ontario, and even before it was in Ontario, for over 200 years. And that is the system that is proposed to be changed by the provincial government now with strong mayor powers. How's it entrenched? Well, in the Municipal Act, you have this. The powers of a municipality shall be exercised by its council. That's in section 5.1, which has not changed with the strong mayor powers. Then 5.3 says how it should be done. A municipal power shall be exercised by bylaw unless the municipality is specifically authorized to do otherwise. So again, taking away some suspense here, specifically authorized to do otherwise is through strong mayor powers, which I will highlight for you. It's a standalone part of the Municipal Act that was put in place initially by the Strong Mayors Building Homes Act in September of 2022. So that's the traditional system of local governance here in Ontario. But you've got this now concept of a strong mayor municipality. Where did this brilliant idea come from? You wouldn't believe it. Well, It sprung from the head of our current premier and his now deceased younger brother, Rob Ford. This quote is attributed to Doug Ford, the current premier of the province, in this book published by a reputable book publisher in 2016. Doug Ford was quoted as saying, "If I ever get to the provincial level of politics, municipal affairs is the first thing I would want to change. I think mayors across the province deserve stronger powers. One person in charge with veto power." Now, where did this come from? Like, why would he have come up with this? Well, just remember, just before 2016, when the book was published, in 2010 to 2014, Doug Ford had been a one-term mayor of Toronto City Council. He had taken over the seat of his brother, Rob Ford, who ascended to the mayoralty office in Toronto for a single term from 2010 to 2014. And I think what the Ford brothers saw was that their idea of how the city of Toronto should operate and should function just wasn't being done. They were being voted down in a number of instances by the rest of council. And yes, remember, the City of Toronto Council was a 45-member council. And sometimes the votes were, and I kid you not, 43-2. And you can just guess who the two were. And I think Premier Ford, now Premier Ford, was thinking, well, if my brother had had the powers of a strong mayor, as they appear in a number of U.S. big cities and jurisdictions, perhaps he would have had the authority at law to veto certain things that city council wanted to do. Maybe he could advance certain things that he wanted to do, but he was otherwise stymied by well, let's put it this way, a progressive council that didn't really want the conservatism of the Ford brothers, okay? Now, he knows something about provincial politics because the father of Rob and Doug Ford was a one-term member of Queen's Park. I think it was sometime in the 1970s, was a member of the provincial parliament. And you got to remember that the patriarch of the Ford family also was the person who created the wealth of the Ford family through a company called Deco Labels and Tags, a very successful company that has its headquarters in the United States in the city of Chicago. And what is the city of Chicago known for? Well, it's known for the Bears, the Cubs, and being the Windy City. It's also known as the last of the big city bosses, which was Mayor Richard Daley in Chicago, who was a strong mayor, who had veto power, who had power to control the municipal budget, who had the power to appoint the heads of certain commissions, committees, and boards at the city, which ran the city. And I think this all informed Doug Ford and saying, wow, I like the way Chicago operates. I like the way some other big cities in the US operate with strong mayors: San Francisco, Los Angeles, New York, and Chicago. And this, I think, informed the view, the vision of Premier Ford, because this is really his vision, his baby here. But in order to put it across, you need an excuse. So he's got this idea of a strong mayor municipality that he thinks is a good governance tool. You need an excuse. Well, what do you have? You have the Ontario housing shortage. Just before the provincial election in June of 2022, when the Progressive Conservative Party, led by Premier Doug Ford, won its second majority government, the Provincial Housing Affordability Task Force wrote the report on their views of Ontario. And the introduction the very first sentence, Ontario's in a housing crisis. That's what it said. And what were the fingers pointing to? All things that seem to reside with municipalities. Development restrictions, i.e. zoning bylaws, development, official plan designations, development charges, building processing fees, planning processing fees, user fees and charges from the Municipal Act, all things that municipalities put in place and that were seen as a hindrance to the creation of new housing in the province. And then the final one, building permit delays. Because why? Well, the province puts in place a building code, a uniform, provincial-wide building code that deals with building and construction regulation across the whole province. But instead of the province having to enforce it, what does the province do? It downloads the responsibility onto principal authorities, principally which is a municipality, local municipality generally, who is in charge of the building enforcement scheme, led by the chief building official who issues permits. And even though there are mandated timing for permits, it is often very difficult for building departments and chief building officials to do a full checklist of all applicable law and all other things that need to be complied with in order to get a building permit, in order to issue a building permit. But yet all the fingers were pointing at municipalities. So you have the vision, and then you have the excuse in order to implement strong mayor powers. So, Mr. Mayor, I'm going to take just a quick beat here and ask if there are any questions. I think that's just all historical there. I'm not sure there's going to be any questions, but if there are, I'm happy to take any.
Okay, any questions? No?
No.
No, we're good here.
Terrific. Then I'll move on. So, but I want to talk a little bit about how strong mayor powers came about before I talk about the actual powers. So here's a bit of, again, a little bit of history, but again, to give you some context. Strong mayor powers, there are 4 sources. There are 2 statutes, there are 2 regulations. You must read them together. In fact, some of them, there's just no way you can do them unless you read them together. So first one, Strong Mayors Building Homes Act 2002. Look at the bill number, Bill 3. This bill was introduced very early in the legislative sitting of Queen's Park, right after the Ford government had won its second majority government in June of 2022. There was no mention whatsoever of strong mayor powers during the provincial election campaign. You would have thought something that would have fundamentally changed the whole nature of local governance would have had at least a mention during the provincial election campaign, but there was none. It came as a surprise when the Strong Mayors Building Homes Act was introduced, because nobody in the provincial Conservative government, including Premier Ford, had said anything about strong mayors. The other parties hadn't, because they didn't know this what might have been forthcoming. So what does the Strong Mayor Building Homes Act do? Well, it puts in place an entirely new standalone part in the statute, Part 6.1. And sometimes I'll refer to strong mayor powers, and sometimes I'll refer to Part 6.1. I'm referring to the bundle of powers in that, and they're interchangeable terms. There was Part 6.1 put in place in the City of Toronto Act, which is CODA, and the Municipal Act for every other municipality here in Ontario. Okay, that in a sense put in place the framework for the strong mayor powers. Then sometime later, I think the province went, oops, I think we forgot to do one thing that's kind of important. And it passed the ironically entitled Better Municipal Governance Act. And you can see it's Bill 39. It was introduced, I think, in October, and it was given third reading and royal assent in early December of 2022. This particular provision, the statute, added one section to Part 6.1 of the Municipal Act. Only one section, but it's incredibly important and has a lot of significance. Now, together with the statute, there are two regulations, and you have to read these pieces of legislation together. So on May the 1st, when Kapuskasing became a strong mayor municipality, how did it become that? It became that by a designation by the Minister of Municipal Affairs and Housing, currently Rob Flack, in this sitting of the legislature, who added the 170 additional municipalities to Section 1 of the regulation, 53022. That's how, technically, legally, the town of Kapuskasing and 169 other municipalities received strong mayor powers on May the 1st. The other thing that this regulation does, apart from just designating municipalities, is it sets up a number of procedural rules and other technical things to deal with the implementation, the operationalization, and the administration of the strong mayor powers. And then finally, there are a number of provisions. There are 3 provisions in the Municipal Act that must only be exercised with reference to prescribed provincial priorities. And there is a regulation that's made by cabinet that prescribes what the provincial priorities are. I will show you the regulation in just a moment before I speak about those particular authorities. But to give it away, the prescribed provincial priorities of this particular government is to have new housing put in place in Ontario and infrastructure that is related to housing. Again, I will show you the regulation because the regulation must work in tandem with 3 specific provisions in the Municipal Act. So here is the rollout of the designations. Originally, the strong mayor powers were only given to 2 municipalities, the cities of Toronto and Ottawa. They were granted only to those mayors, and the statements by both Premier Ford and former Minister of Municipal Affairs and Housing, Steve Clark, said, this is a pilot project. We're going to test drive this to see how it works. It was very interesting because former mayor of the city of Ottawa, Jim Watson, did not want anything to do with the strong mayor powers and sought to disclaim them to the extent that he could and delegate back the ones that he was entitled to do so back to city council and others. But he sought to not use them. Mayor John Tory, former Mayor John Tory of the City of Toronto, on the other hand, embraced them. And in fact, it was shown that he had been secretly lobbying the provincial government for some type of stronger powers in his office in the City of Toronto. So 2 very divergent points of view. So why were they given to Toronto and Ottawa? Well, Minister Steve Clark and his parliamentary assistant in the House debates at the legislature were very, very clear. The cities of Toronto and Ottawa are the 2 biggest municipalities in Ontario. One is the provincial capital, the other is the national capital. These municipalities were in the greatest need of housing. They were in the greatest need of affordable housing, and they were shovel ready. I think the minister twice used that term in the Hansard debates, and he certainly used it in media reports where he said these municipalities are shovel ready and good to go. So remember, only Toronto and Ottawa initially, because they are large cities ready to go forward with development for new housing. Then, about 10 months later, on June 16th, 2023, it was announced that 26 additional municipalities would be designated as of Canada Day of 2023, where their councils would sign on and make a commitment to the provincial housing construction targets. And these municipalities that were chosen were municipalities chosen based on population. They either had populations of 100,000 or more, or were projected to have populations of 100,000 or more within a certain number of years. So the original decisions to give strong mayor powers to the first tranche, or I guess the second tranche of municipalities, 26, were based on council committing to the provincial housing construction target and a certain population number, an urban population for these municipalities. The third tranche came very quickly. It surprised many, including me, that I thought they were going to hold off. I still thought it was a pilot project. Sometime in mid-September of 2023, the former Minister of Municipal Affairs and Housing went to 21 municipalities and he said, hey, if your mayor makes a pledge and signs on to the provincial construction housing targets, then your municipality that has currently a population of 50,000 or is projected to have a population of more than 50,000 over a certain number of years, you will get it. So interestingly, the population centers went from 1 million plus to 100,000 plus to now 50,000 plus. It went to, we're giving it to you if council agrees, and then we're giving it to you if the mayor agrees. Now, only 18 municipalities, their mayors actually signed the provincial housing construction target pledge. 3 municipalities could not commit to those targets, basically due to servicing issues in their municipalities. So this is how it went. Then there was a 4A tranche, and I'm saying that jokingly. The city of Orillia on April the 3rd was granted temporary strong mayor powers by current Minister of Municipal Affairs and Housing, Rob Flack, which he claimed he was giving to Mayor McIsaac in Orillia to deal with, wait for it, not building new homes, but to deal with a state of emergency in the municipality. Now, I'm sorry, I thought the whole intent of the strong mayor powers was to build more homes. And yet you have the minister and Mayor McIsaac of Orillia saying very clearly, we're giving you these powers and I'm getting these powers to deal with the state of emergency. So where's the intent of building strong homes there? Okay, so that was sort of 4A. Then the real 4, the fourth tranche, was announced on April the 9th. The Ontario Newsroom at about 9:30 a.m. that morning issued a media release entitled Ontario Proposing to Expand Strong Mayor Powers to 169 additional municipalities. No prior notice had been given to municipalities of the proposed new powers to be granted on May the 1st. What was really fascinating here is the legislation, for the first time, was posted on the Ontario Regulatory Registry for an entire period of 1 week for the commenting period. Many municipalities reached out to me at that time and said, we don't want these powers. Can we disclaim them? Can we ask the minister not to give them to us? And of course, I looked at this and I went like, well, this is unusual. The province actually put this on the ORR. Well, it must mean that the province is giving everybody an opportunity. And if you don't want it, do this. Make sure that you have a meeting. Make sure that you have a council resolution. And if you can include the mayor in there and perhaps have a unanimous council resolution that these powers are not needed, not wanted, not necessary for your municipality, my opinion was, I think you've got a good opportunity to have these not put in place. Well, that didn't really happen. The minister on the next slide, I'm just going to advance it, wrote to 170 municipalities. Yes, they included the city of Orillia to make them full-time. I guess maybe this time it is to build houses. This letter was sent by Minister Flack indicating that pursuant to the earlier commitment that the province made, your municipality, including 169 other municipalities, would be receiving strong mayor powers. Now, this was sent to all municipalities. It would have been sent to you, Mr. Mayor, at the town of Kapuskasing. It was sent to 169 other municipalities in the same form. This is just the first paragraph. There was about a page and a half letter there. But just going back one, the proposed powers were not this time granted based on population. If you look at some of the municipalities on that list, they are very, very small rural municipalities that have no way to possibly provide the necessary servicing to provide any kind of significant new housing starts. Yeah, maybe there might be some, but not new escalated housing costs, housing starts for the province commitment of 1.5 million new homes. They were also given to all municipalities like the town that had 6 or more members. Because the town of Kapuskasing has 7 members on its council, you were selected. This was the criteria. So population and population growth were no longer a criteria. I think the province, my own view, this is my speculation, I think the province is intending to give strong mayor powers to all municipalities in Ontario. And I think they wanted to advance it to an additional group. And there had to be some sort of cutoff. And I think the cutoff was, well, let's take any municipality that has more than the minimum 5 members of council. That's what's required in the Municipal Act as a minimum for every municipality. Any municipality has more than 5, we're going to extend these powers to. And provided the municipality was a single-tier municipality or a lower-tier municipality. So no upper-tier municipalities included for strong mayor powers. That's interesting. I think it might be sending a signal to many municipalities as to where the province is heading with respect to upper-tier governments. So AMCTO, the Association of Municipal Managers, Clerks, and Treasurers of Ontario, come out very strongly against the legislation, saying this is not a good thing. It erodes the basic administrative authority between the head of council and the chief administrative officer, and serves to politicize the local government administration, something that Justice Morocco in the Collingwood Judicial Inquiry had very strongly come out and said it is imperative for municipalities to have a neutral, impartial, politically objective administration that would give wise counsel based on the merits of the question that were before council for decision making, so that council could get that proper advice and not just have yes persons. OMA, the Ontario Municipal Administrators Association, association that I've done some work for and did some work in this area, also came out very strongly and made statements and provided communications to the province saying this is not good legislation. Now, AMO, which represents almost every municipality in the province, well, not so much so. I got to say, AMO has been very lacking in trying to make a good statement here. In fact, their president was quoted in the press release about how wonderful these powers could be. So I'm really concerned about where AMO may be going with some of this. It's not, in my view, legislation that's been well thought of or really is good legislation. Certainly not legislation that, in my view, my own humble individual opinion is, I'm not sure it's going to lead to greater housing starts in the province. And AMO just hasn't been very forceful in saying much about this. So I'm now going to go to the actual powers. But before I do, Mr. Mayor, I just want to ask again, I'm going to take a pause. Any questions from you or any other members of council?
Yeah, I think there may be a few here. So, Mel?
It's not really a question, maybe more of a comment. When you're saying that in the first one of the first slides, you said the mayor has a single vote. It was my understanding that depending on the procedural bylaw, sometimes the mayor will only have a vote pour trancher la décision versus a vote at every decision. C'est-tu moi qui I'm not too sure about that one. And then depending on the procedural bylaw, the mayor already has some, I think, things that he can vouch on more than just the council itself. So I was wondering what's the comparison now?
Sure. So if I could, Mr. Mayor, I'll answer those questions. Every member of council is entitled to a vote. That's the Municipal Act. Now, if procedure bylaw puts in something different, I'm not sure it actually has some strength in it. I know, and I've seen these, a number of procedural bylaws will say that the mayor can vote, but only to break a tie. I don't think that that's what the Municipal Act actually says, and I think that's wrong at law. But I fully acknowledge that that's what some procedural bylaws say. And yes, some procedural bylaws do give the mayor some enhanced authority. Some councils give the mayor certain delegated authorities, but that's not statutory. That's through council. I was speaking about a statute giving unilateral executive authority to a mayor. And if you look at the Municipal Act and other statutes, they are very few and far between. If you can name me 5 of them, I'd be really surprised. I'll give you a couple. One is the mayor, without anyone else chiming in, without having to ask anyone, the mayor can expel anyone at a council meeting if they're unruly, disruptive, disobedient, can expel someone, doesn't have to ask anyone. The mayor is, of course, the person who declares a state of emergency under the Emergency Management and Civil Protection Act. Doesn't have to ask anyone, and it is the mayor who's given statutory authority to implement a certain emergency plan under that statute. But name me some other unilateral authority that's given by statute. Anyone? Like, there really isn't much. So I was talking about statutory authority beyond what council itself can, through a procedure bylaw, a delegation bylaw, or otherwise, grant to the mayor. There are very few and far between. And Councillor, thank you for the comment. I will talk about how the law has changed when I talk about the powers that are on the screen now.
Okay, and I had another comment. So it was just when you were discussing a little bit earlier, stipulating about the developmental fees, levies, charges, building permit delays, that it was really a problem, but it was my understanding that the municipal staff have to go through that because of the provincial legislation and not because necessarily of the municipality. So I just wanted maybe a little bit more information on that note.
Yeah, so again, you've made your point is, and through you, Mr. Mayor, I apologize. Yeah. The point was in the report, the Housing Affordability Task Force, it seemed to, as I indicated, point all fingers at the municipality being culprit. Well, who sets up the system? And I was trying to make this reference with, especially with the last one, which is, they pointed out that, building permit delays, that's a municipal problem. Well, is it? I mean, the province is constitutionally the level of government that has jurisdiction over municipalities and sets the ground rules for municipalities. It's the province that allows municipalities to charge development charges under the Development Charges Act, to put in place planning processing fees under Section 67 of the Planning Act, building permit fees under Section 7 of the Building Code Act, and user fees and charges under the Municipal Act. The province allows that. So it's really interesting how the province somehow has taken the view here, oh, you need strong mayors to override this municipal quagmire, to disentangle all of this bureaucracy, when quite honestly, the province could itself have done it, and in fact has come and has done this. And I apologize, I forget the bill reference, but there is a bill that was in front of the provincial legislature that was talking about clawing back a bunch of authorities, making it easier to get building permits in certain instances, rolling back development charges in other instances, and certain planning authorities, say the 10% numerical variance from the standards of zoning, right? So you can see the province now went like, well, we have the capacity to do that there. So I'm not sure why they would have decided to do strong mayor powers. So I think that's what the point was you were trying to make, Councillor.
Right. Go ahead.
I have a question. In Ontario, we have lower tier municipality, separated town, and upper tier municipality. Is this regulation applied to separated town too?
I'm sorry, I didn't understand the question. I apologize.
In Ontario, we have lower tier municipalities, upper tier municipalities, and separated town like Brockville, Smiths Falls, Prescott, if I remember. Is this regulation applied also for all the separated town?
So he's calling them separated towns, so they apply upper, lower, and single tier.
They're not part of the county or this quick.
So
Single tier.
yeah. So yeah, more specifically, these apply to single tier and lower tier, correct?
Yes, I'm sorry if that was the question. There are no strong mayor powers given to any upper tiers, whether it's a district, a county, or a regional government, regional municipality in Ontario. These powers have only been granted to date to about 49.2% of all municipalities in Ontario that are either single tier or lower tier municipalities that have 6 or more members of council on their councils. That's the criteria right now for all of the ones that have been granted strong mayor powers.
Okay, thanks, John. Any other questions? No? Okay, so I think we can proceed.
Okay, so Mr. Mayor and members of council, I'm now going to turn to the actual strong mayor powers. I know it's taken us a little bit to get there, but I think some of the context might be beneficial to you. I hope it is. I've divided the strong mayor powers into 3 groups, 3 categories. The first one I've called administrative powers. Some municipalities have been calling them administrative/political powers. I don't disagree with that, and I'll explain why. The second group is provincial priority powers. Some municipalities refer to these as legislative powers. Again, not incorrect, but I think the better moniker is provincial priority powers because these 3 powers can only be exercised for provincial priorities. And I'll explain that in a moment. And then there is the budget power, or, Mr. Mayor, you may correct me, the budget responsibility now lies with the head of council, no longer council, unless there's a default. So I will go through each one of these. And again, Mr. Mayor, once I get through each one, I will take a short break and ask if there are any questions. So let's start with the administrative powers. The first power, direction to employees. There is now specific, explicit authority for the head of council to direct municipal employees. That's the term that's used. It is not a defined term in the statute. Municipal employees to do this, to undertake research, to implement decisions, and to provide advice to the head of council and to the municipality. Now, if you're saying to yourself, that sounds vaguely familiar, you'd be right, because that language is very much lifted from section 227 of the Municipal Act, where it speaks to the municipal administration. And it says, one of the things that the municipal administration shall do is to undertake research, implement council's decisions, and provide advice to council. So that section has been taken and has been changed in 284.3. The head of council now has the authority to exercise the direction giving power to municipal employees. But I've stated it very broadly. The powers only extend to doing things that are authorized under part 6.1. So these powers to give directions to municipal employees can only be exercised with respect to the strong mayor powers. Remember, originally, the whole intent of the strong mayor powers was to do one thing, well, two things: build homes and infrastructure related to homes, to construct and maintain those things, okay? This power here to give directions, not related explicitly nor directly to building homes. There's no reference in section 284.3 that speaks about homes. So I want to be very clear about that. In fact, all of the administrative powers, and I'm going to show you a few more, none of these are directly related to building homes, constructing homes. Okay, I'll explain why in just a moment, but let me get through them first. So the head of council can give directions to municipal employees, but only with respect to the authority that the head of council has under part 6.1. Now, if you're worried as a member of council or staff, oh, the mayor's going to whisper in someone's ear and say, don't tell anyone, but this is what you've got to do. It doesn't work that way. None of the head of council's powers to give direction can be done orally or verbally. They must all be set out in writing. The province has touted this as an accountability transparency mechanism. Well, okay, it is there. Okay, so direction to employees, first administrative power. The second one that you probably have heard about that has received some notoriety, the authority currently to hire or dismiss the chief administrative officer resides with council. In fact, the CAO is often referred to as council's one employee. This has now changed. The powers of a municipality under section 229 with respect to the chief administrative officer are now assigned to the head of council. Many persons have misinterpreted what that says. It's not the assignment of the CAO's powers that are delegated here. It is the power to appoint, and which comes with it, the power to remove the CAO, which is now the authority of the head of council. This power can be granted back or delegated back to council. Okay, and I'll show you a slide right at the end of the administrative powers. Okay, so the first one is the hiring and dismissal of the chief administrative officer. Now it is the CEOs, the chief executive officer, the mayor, who can remove and hire the CAO. The municipal organization. The head of council has the authority to determine the organizational structure of the municipality and to reorganize the municipality. Now, if you're looking at the words organizational structure, this is not a defined term. I asked two of my employment lawyers at the firm who work with me with my municipal clients, what does organizational structure mean in the employment law context? And they said, it's not a term of art that we use in the employment law context. I said, really? They go, you know what? If you look up any important statute dealing with employment law in Ontario, It won't use that term. Well, I test drove them. I didn't believe them, and I keyed in the words organizational structure under the Employment Standards Act, the Occupational Health and Safety Act, and the Labor Relations Act. They were right. It doesn't show up anywhere in any of those statutes. It is not a term that's was used essentially before this legislation with respect to municipalities, or I guess employers. What is an organizational structure? Well, I think it's your organizational work chart that your municipality has. Every municipality's organizational structure will be different, just like every one of its reporting structures is going to be different. The mayor now has the authority to change the organizational structure of the municipality. Together with that power is an inclusionary power, and that is that the mayor now has the right to hire and dismiss and to exercise any prescribed employment law powers with respect to division heads and persons who are the heads of divisions of the municipality. So there are no prescribed employment law powers. So the mayor currently has the authority to hire and dismiss any division heads. Now, what is a division head? Once again, not a defined term. Every municipality will be different depending on its organizational structure. Now, I've written it there in my first sub-bullet. I put department/division heads, because when I was thinking division heads, I was thinking they must be talking about department heads. Interestingly enough, when I was reading the debates at Hansard, former Minister Steve Clark kept referring to division heads, not as division heads, but as department heads. So I don't know if I picked that up or if I had that in my mind, and so did he, because we both made, I think, the same mistake. I don't know that he actually even ever referred to them as division heads. I think he would always call them department heads. Who that is in your municipality, I could not tell you unless I looked at your organizational chart and probably sat down with your CAO as well as your manager or director of human resources to try to figure that out. Now, while the mayor has the authority to hire and dismiss these people, which makes sense, right? If the mayor can reset the organizational structure of the municipality, for example, there are 8 departments or divisions that report to the CAO. The mayor could say, that's just too many. I'd like to see 4, or I'd like to see 6 or 5. The mayor could do that, but if he's resetting that organizational structure, it might mean that some people might be displaced. So it makes sense that the mayor is able to hire and dismiss division heads. Then there's a carve out, except any division head who is a statutory officer. And there's, I think, 10 of them listed or 9 of them listed, the ones that you would know: the clerk, deputy clerk, the treasurer, deputy treasurer, the chief building official, auditor, integrity commissioner, fire chief. Those persons cannot be displaced. And interestingly enough, any other officers who are required to be appointed under any other act. So interesting enough, while the mayor has the authority to remove division heads, could not, for instance, say, I'm going to dismiss that building inspector, because the building inspector is appointed under 3 sub 2 of the Building Code Act. Could not dismiss the drainage superintendent, who is appointed under 124 of the Drainage Act. Could not remove the weed control officer, who is appointed under Section 9 of the Weed Control Act, and so on. Very interesting how this works. Any organizational structure that is in place as of May the 1st for your municipality remains in place unless the mayor changes it. And I've been asked this question. So the mayor is entitled to remove division heads. Can he remove them without cause? And the answer is unequivocally, absolutely yes. You don't need cause. If you can redetermine the organizational structure, then concomitant with that power goes with the authority to remove certain people from their employment. You do not need cause. The second corollary question that I've been asked is, well, can the mayor do so with impunity? And the answer is no. And that's partially covered by my last bullet on the slide. Any division head remains employed unless dismissed by the head of council. And the law here is that if a division head is in place as of May the 1st, that division head will have certain benefits either under an employment contract, employment agreement, or at common law. Any person who is dismissed without cause would be at law entitled to notice and severance and potentially damages. That remains in place. So if a head of council would like to remove a division head who is not a statutory officer, can do so without cause, but there may be consequences, financial consequences to that decision. Okay. Now, this power for the organizational structure, this can be delegated by the head of council back to council or to the CAO. It is expressly permitted. Now, the two additional powers that I've put under administrative, but that some municipalities are calling political, are with respect to prescribed local boards and prescribed committees. With respect to prescribed local boards, the mayor can appoint the chairs and vice chairs of prescribed local boards. But don't get too excited, anyone, because there are none that are prescribed. Prescribed, by the way, means in the regulation. And there is nothing in the regulation right now that prescribes a local board. So the mayor can't make any changes to any existing local boards and appoint the chair and vice chair. With respect to prescribed committees, hallelujah, we actually have a defined term for what a prescribed committee is. It's under Section 4 of Regulation 53022. It means a committee that consists solely of members of council. Now, when I first read it, I thought it meant committees of council, essentially being committees comprised of all members of council. That's not what the language says. It says a prescribed committee is a committee consisting solely of members of council. So if the mayor would like, the mayor is entitled to create a committee of a council or a committee, a prescribed committee, consisting solely of members of council that have 2 members or 3 members, right? He can do that. Or it can be all members of council. And if that's the case, the mayor is entitled to establish the committee and to dissolve any existing committees that are comprised solely of members of council, can appoint the chairs and vice chairs, and can assign functions to these committees. That authority is in place and can be exercised. These two authorities, even though the first one, as I've indicated, is the empty shell, both of these authorities are specifically authorized to be delegated back to council. And why do I say that? Because Section 283.13 is the delegation provision. There are 4 specific powers that relate to the administrative political powers that a mayor can decide to delegate back. And I've put in place there which entities he can delegate back to. 3 of them can delegate to council, actually 4 if it was local boards. 1 can delegate to council or to the CAO, and that's with respect to the organizational structure. But notice in my first bullet there, I said the head of council may delegate the following powers and duties in accordance with Section 23.1 sub 2 of the Municipal Act. If you look at that section, it is a number of rules. I think there are 7 rules that apply for how delegations will occur. The first rule, I'm not sure if it's the first rule that's written, but let me tell you the one that I've been asked the most is, if the mayor delegates today, can the mayor revoke tomorrow? And the answer is absolutely yes. In fact, anyone who has an authority at law, they are entitled to delegate. If they are entitled to delegate, they may do so, but they still retain the power, which is interesting. So does the power, if it's delegated, does it continue to run into the next council term, whether the current mayor is in place or whether there's a new mayor in place? And the answer is yes, it continues to run, but it can be changed by the re-elected mayor or the new mayor that's been elected. So it can change. And so I would urge anyone who is looking at delegation of authority to look at the powers under 23.1 or the restrictions there as to some of the rules that can may be attended to with respect to the administrative power delegation. Once again, these are the administrative powers which do not need to be tied directly to strong mayor powers with respect to building new homes. So the question is, well, why were these powers given? Like, how does putting someone in the chair or vice chair of a committee, or how does reorganizing the structure of the municipality relate to building more homes? The answer is, it may not. That doesn't mean that the exercise of these powers is wrong. That's a decision that the provincial government took, and it decided to do that. Why? Because if you again look at that debates in Hansard, Minister Clark was very clear. We looked at big cities in the United States, San Francisco, Los Angeles, New York, Chicago. In those instances, the mayor sometimes was not even a member of council. The mayor stood outside of council, but the mayor could veto council decisions. The mayor had responsibility for the budget. And yes, I will still get to that. And the mayor could appoint the chairs, vice chairs, and sometimes other persons to important committees, commissions, boards, and tribunals. So that was the reason underlying these powers, which are not expressly and directly related to building homes and infrastructure related to homes. Okay, Mr. Mayor, members of council, I've come to the end of the administrative political powers. Any questions on these?
Any questions? No question. No, we're good to go.
All right, so next I'm going to turn to the provincial priorities. The authority here is in the statute for the cabinet to prescribe provincial priorities. This government's provincial priorities are homes, lots of them by the end of 2031, and infrastructure related to homes. Let's just say that the Ford government had not won a third consecutive majority government in the February election. Let's say the NDP had won it, and it was Marit Stiles who was our premier. Could provincial priorities have changed? Yes. Now, I would think the NDP would be all in favor of building more homes, probably in favor of building affordable homes. Could the NDP have come in and maybe had some labor relations matters? Yes. What if the Green Party had won? Would we see perhaps provincial priorities more keyed towards environmental issues, health, safety, welfare, climate change? Potentially. The provincial priorities are dependent on the government of the day, and they can be changed by the cabinet. This provincial priority of this government is housing and infrastructure related to housing. And there are three powers that a strong mayor can exercise with respect to provincial priorities, okay? The first one, oh, sorry, I meant to show you. This is the actual regulation, 58022. I've shown it to you already in various iterations. Number one, building 1.5 million new homes. Well, that was from the Affordability Task Force report. And then, of course, constructing and maintaining infrastructure to support housing. Okay, that's what the provincial priorities are. Okay, so the first one, as you know, a municipality must have a procedure bylaw. Every municipality must enact a bylaw having a procedure bylaw under Section 238 of the Municipal Act. What does the procedure bylaw prescribe? Well, it talks about the calling of meeting, the location of the meeting, and for the rules of engagement, how things are passed, how business is conducted at a meeting. Well, now, despite what the procedure bylaw says, the head of council may require council to consider any matter that, in the head's opinion, potentially advances a prescribed provincial priority. That is now new. So without a notice of motion, without it being on new business or however else your procedure bylaw may guide you for new matters, the head of council, if the head of council forms the opinion that there is a potential advancement of a provincial priority, then the head of council can require council to consider the matter. Now, unlike a power that I'm just going to show you in just a moment, the head of council can't require council to vote on the matter, but can require council to at least consider the matter. That's the first one. The second one that's received some notoriety, the veto power. The head of council has the express authority to veto a bylaw that is enacted by council that the head believes will potentially interfere with a provincial priority. Now, the bylaws that can be vetoed, one, must be a recent bylaw, and I'll explain what I mean by that. And two, it must fall within a grouping of bylaws under statutes. The Municipal Act, a bylaw under that statute, the Planning Act, or any other prescribed statute. And there is one statute that's prescribed, I think, under Section 5 or 6 of the regulation, and that is Section 2 of the Development Charges Act. So if the mayor is of the view that a bylaw under the Municipal Act, the Planning Act, or a development charge bylaw potentially interferes with the delivery of a prescribed provincial priority, the mayor can veto the bylaw. Now, earlier I said can veto a recent bylaw. The reason I say that is because the legislation says if the mayor is going to exercise the power of veto, the mayor must give notice within 2 days of the council vote. Well, what does this mean for your municipality? It means that prior to May the 1st, the mayor can't go back in time and veto a bylaw. In fact, can't veto a bylaw that was enacted last time unless the mayor had given notice. Must give notice within 2 days of the vote of council. Thereafter, the mayor, if he would like to exercise the full veto power, must do so by providing the clerk within 14 days of the original vote of council with a document that supports his view that there's a potential interference with provincial priorities. Must put it in writing. That is the veto. Now, what's really interesting here is council is entitled to override the mayor's veto. So council doesn't like the fact that the mayor has vetoed a recent council bylaw. Council can override the veto, but here's the hitch. Council can only do so by a 2/3 vote of council. So let me be very clear. 2/3 vote of all members of council. You have council 7 persons. You can have quorum for a meeting with only 4 persons. 3 people can be absent, but Section 238 of the 237 of the Municipal Act says a quorum of council is the majority of the members. So with 4 members, you can have quorum, but it's not enough to get a 2/3 vote. You would need 5 members of council to vote. It's all members of council. If the province had intended to say it is only a vote of 2/3 of the members present, it would have said so, and it didn't. So the interpretation here, my interpretation as well as many others, is that it is 2/3 of all of council. In your municipality, that's 5 members. While you can have a meeting with only 4, you wouldn't be able to pass a veto or an override to the mayor's veto. And here's where it gets really tough. The head of council is entitled to vote. So all members of council can vote, and the mayor's entitled to vote. Presumably, the mayor would not vote to veto his own veto. So that is the veto power. The final power for prescribed provincial priorities relates to one that has received a lot of notoriety. This was the one that the province went, oops, we think we forgot something. So it allows the mayor to veto a bylaw if it interferes with the provincial priority. This power allows the mayor to advance a bylaw if he believes that it potentially advances a provincial priority. And again, it's a bylaw under the Municipal Act, under the Planning Act, or it's a development charge bylaw. The mayor may advance that by bringing forward the proposed bylaw with supporting reasons. This is material. Mayor must have supporting reasons. What would those supporting reasons be? Well, he has to somehow say it potentially advances the provincial priority. So I think that's what the supporting reasons would go to. And get this, the mayor may require council to vote on this. That is really interesting, because I've been asked the question, what if a member of council doesn't want this to go ahead? Can they just leave the meeting, have a loss of quorum? The answer is, I don't think so. Council can be required to vote on the matter. That means, I think, if any member should try to step away or en bloc, all of council should try to step away, or sorry, all of council except the mayor, to lose quorum. I don't think that would be permitted. The mayor can require the vote. So it would be some form of council disobedience contrary to law if council were to get up and leave the meeting to cause quorum to be lost. The language is the mayor can require council to vote. Okay. And finally, with this, the bylaw may be enacted with simply more than 1/3 of a council vote. This is the section that's been termed to be completely undemocratic, because the history of Ontario local government is majority rules. You have to have a majority vote, whether it's a simple majority, a 2/3 majority, or a super majority of 3/4. You've always had to have a majority vote. In this instance, the bylaw may be enacted by just more than a 1/3 vote of council. Your municipality has 7 members. You take 1/3 of council, that's 2 1/3, and you add the mayor. So with 3 votes, you can pass the bylaw under this section. Finally, the head of council is entitled to vote on the 1/3 plus council. That's why I always say the vote is the mayor plus 1/3 of council. There is one bylaw that has been challenged, and it was in the city of Peterborough. The mayor of Peterborough, Mayor Leal, got a bylaw enacted under this section with a 4-7 vote. That council has 11 persons. If there had been 12, you would have had 4 out of 12. If we do that math, that is not more than 1/3. The language here is more than 1/3. You would have had to have another vote, so you would have had to have 5. But with an 11-member council, 4 votes was enough to garner the support. Interestingly enough, that bylaw has been challenged in court. The application was not a judicial review application, and it was not an application to quash, which greatly surprised me. It was simply an application under the rules of civil procedure. And basically the argument was this: the mayor passed the bylaw under this authority. The mayor should not have done so. That's it. That's the gist of the argument in court. I didn't see much more than that. I'm wondering if it's for a nuisance claim. So there is one challenge of which I'm aware of. By the way, I should have said this earlier and I didn't. There is no case law that's developed on all of these strong mayor powers. The legislation has been in place for almost 3 years. The Strong Mayor Building Homes Act was enacted in September of 2023. Then they added this one section in December. It has not changed at all since then. The only change that has been made is the number of municipalities that have been added to the designated list of municipalities of strong mayors. So nothing else has changed. We don't have any judicial determinations that will help us on what is the meaning of a division head, what can the mayor do, what is legal, what is bad faith, all these questions that still remain to be answered 3 years later. That is the comments, Mr. Mayor, members of council, on provincial priority powers. Are there any questions related to these powers?
Yes, here, Bruce.
Hopefully it doesn't happen. What happens if the municipality accepts the strong mayor power and the existing mayor falls sick? Do you have to take a revote to accept it for that term?
So I just want to answer the first part. I'm not sure I understood the second part. So the first part is the municipality doesn't have to accept anything. The province has put this in place, and the strong mayor powers are there now. The municipality can't disclaim them. The municipality can't accept them. They are foisted upon you. You, Kapuskasing, 169 other municipalities and the 46 that came before you. And I'm sorry, I didn't get the second part of the question. It was, what if the mayor does not do something?
Well, the existing mayor falls sick.
Do the powers go to the deputy mayor, for example?
Yes, exactly.
Thank you. No, they don't. At a recent webinar that Municipal Affairs put out just a couple of weeks ago, I attended it. This is the one helpful thing that they actually did say in that. There had been some dissension from that point. If the mayor was not available for medical reasons or any other reason, could the deputy mayor or an interim mayor or an acting mayor, could someone else step in the mayor's shoes and exercise these powers? And the answer is no. I thought it was very clear in the legislation. The City of Toronto had consulted with me earlier about this when they had received the powers, but the City of Mississauga took a very different approach. They said, no. If we have a deputy mayor or someone sitting in the mayor's chair, that person has the authority. Municipal Affairs says, no, it doesn't work that way, which has always been my understanding. So the answer is there is no proxy, there's no assignment, there's no delegation of the strong mayor powers to anyone other than the strong mayor who has been elected to be the strong mayor.
Okay,
Thank you very much.
any other questions?
Yeah, just further to that, so in other words, if the mayor passes away and we have to elect a new mayor, or can we appoint a new mayor? Does it make
Yes.
a difference?
Thank you for that question through you, Mr. Mayor. I was going to get to a slide, but I'm just going to advance the slide if you don't mind. There is a slide up ahead, the vacancy of head of council. So if there's a vacancy in any office of a council member, the rule used to be that council had 60 days from the declaration of the vacancy to do one of two things. One, appoint someone, or two, run a by-election. With respect to the strong mayor can only be elected unless the vacancy falls within 90 days of the regular election, and then council can appoint someone. Otherwise, the mayor must be elected. Now, does acclamation mean election? Yes. Under Section 37 of the of the Municipal Elections Act, it says elected by acclamation. So acclamation would serve that. But no. So the answer is, if something should befall the mayor should be removed from office, or something happens, council would, unless they're within 90 days of the regular election next year, in 2026, council would have to run a by-election to fill the vacancy.
Okay, thank you. Any other questions? All right, we're good to go.
Okay, and now I'm going to speak just very briefly. I only have one slide on the budget power, or you may correct me, Mr. Mayor, on the budget responsibility. It is now the responsibility of the head of council who shall prepare a proposed budget for the municipality, and must do so on or before February the 1st of the year for the budget. If the head of council does not come forward with the proposed budget by February 1st, the head of council forfeits the ability to do so, and then it becomes the responsibility of council to prepare and adopt the budget. There is no authority to delegate or to assign the budget responsibility. It remains with the mayor. However, even though you can't assign it fully or delegate it fully, Mr. Mayor, you can give direction to your staff under Section 284(3), the direction power, to do whatever you would like. For example, you could say to your staff, the CAO, treasurer, clerk, or one of them, or all three of them, or two of them, you could say to them, look, we've been doing really well in how we've set our budgets for the last number of years. I'm giving you direction to run the same program. Set up a budget committee, have public meetings, bring forward the capital and operating budgets at these times. You could do it that way and essentially have the budget come forward as it's normally done. The only change at the end would be at the meeting, the final meeting when the budget's coming forward, is, Mr. Mayor, you would be bringing it forward. Now, you bringing it forward could be, I'm bringing forward the budget, the treasurer will tell you all about it. So it can be like that. Now, you can have something very different from that. You could say, no, I'm a mayor, I'm a chartered accountant, I'm going in there and I'm going to work with the treasurer and we're going to work on this. We're not going to have public meetings, we're not going to have a budget committee. You can do that. You could say to your staff, I want you to come forward with a draft staff budget for consideration by council on this date, but I want it to be a 0% tax increase, or a -2, or a +5. You can do any of those things. That's what the mayor can do in giving direction. Now, on the date that the mayor actually brings forward the budget, because the mayor's got the responsibility, again, unless you forfeit it by not bringing it forward on or before February 1st, then the council can adopt the budget, or council can propose amendments. If the head of council does not agree with the amendments, the head of council can veto those amendments. And similar to some of the veto powers that you've seen before, the council may veto the mayor's veto, but it's with a 2/3 vote. There are a number of timing considerations in which this shall be done, and they're all listed in, I believe, Section 7 of the regulation, and I will not be going to that granular level of detail today. So the budget is the mayor's budget. If you like the way you've been doing the budget in years past, you can give directions to staff to essentially follow that same process. Otherwise, it's your budget, Mr. Mayor, and you can give direction to bring it forward in any way that you believe is appropriate, with council's ability to propose amendments, with your ability to veto the amendments, and with council's ability to come back and veto your veto. None of the budget has to be strictly related to prescribed provincial priorities. So the vetoing of the budget doesn't have to be done because the mayor did not adhere to prescribed provincial priorities. This authority, the budget power or responsibility, is a standalone. It's apart from and not directly related to the prescribed provincial priorities of housing and infrastructure. All right. Any questions on the budget?
None here.
Okay, so Mr. Mayor, members of council, I will now just speak to some of the miscellaneous provisions. We've talked about the vacancy already, and then I will wrap it up, and then I'm happy to take any more questions if you have anything that you'd like to ask me. So this section, I think, has been misread, and I think it's been misread because of its title. It's entitled Immunity, and I think anyone looking at this would go, oh, a mayor's decisions are immune, inexorably immune. You can't challenge them. That's not actually what it says. It says a decision made or a veto power, other power exercised legally and in good faith under this part shall not be quashed or open to review in whole or in part by any court because of unreasonableness or supposed unreasonableness. Now, I've, at the bottom of this slide, referenced 272 and 273 of this slide because the language here was borrowed from those two sections. Section 272 says you can't challenge a municipal bylaw on the basis that you're saying it's unreasonable. Okay, so they've got that concept. Section 273 says a municipal bylaw, which is defined as being a bylaw, resolution, order, or approval, can be challenged by an application to quash by any person within 1 year of its enactment if there's an illegality. And illegality has been determined to include bad faith. What's illegality? There is a law that says you cannot do that. What is bad faith? A lack of candor, transparency, accountability, openness, and acting for an ulterior or illegal motive. So there's a precise meaning. So if a mayor does not act legally or does not act in good faith, those are ways in which a mayor's decision, veto, direction can be challenged. Okay? Now, people have said to me, what if the mayor passes a bylaw with more than 1/3 vote? Does this section mean that someone can't appeal that bylaw to the extent that there are still third-party appeal rights existing in Ontario? Does that mean that they can't challenge it on good planning grounds in front of the Ontario Lands Tribunal? And my answer is no. This does not immunize that. It only talks about a court, right? Not quash, not open to review. Well, an appeal to the OLT is not a review per se. It is an appeal. So, and it's not a court, clearly, it's an administrative tribunal. So it does possibly leave alive challenges made on the validity of the bylaws based on good planning grounds, or if it's a development charge bylaw, on whatever grounds would uphold a development charge bylaw or a municipal bylaw. Okay. We've talked about the vacancy of the head of council. The requirements are all of the mayor's exercises of powers or duties or responsibilities must be in writing. The mayor must provide a written record by the next business day to each member of council and to the clerk, and the clerk must, subject to MFIPA, make the written record available to the public. Now, how it's done? It's up to each individual municipality. Most municipalities have been setting up a separate web page on their website, which is entitled generally mayoral decisions, and those include mayoral decisions, directions, and vetoes. In my view, most mayoral decisions, whether they're vetoes, directions, or actual decisions proper, appear to have been written in the form of and excuse the pejorative connotation, but as an executive order. That's what they look like to me. There's generally a short title at the top. There's almost always a reference to the statutory and or regulatory authority under which it's made. And then there are some recitals, typically not a ton of them. They're usually relatively brief. And then finally, there is one paragraph or a short number of numbered paragraphs that look to me very much like an executive order signed by the mayor and dated. Those are the way they've been generally coming forward. There is a regulation-making authority beyond the minister designating municipalities to be strong mayor municipalities and the cabinet prescribing provincial priorities. There is an authority to the Minister of Municipal Affairs and Housing under Part 6.1 to prescribe anything that may or must be prescribed, to do certain things with respect to the budget. So there's, I think the province is looking at this saying the minister may need to still weigh in on this. And then there's this curious one right at the very bottom, which allows the minister to bring forward a regulation that may be retroactive. And I'm wondering if the only reason that's been put in there is sometimes potentially a mayor may take a misstep and it might be challenged. And I'm wondering if the minister would come in, pass a retroactive application of a regulation and say, we're putting this in place, and it retroactively will come before the mayor's decision and therefore put it in good standing. I think that's the only reason I could see for the regulation being, this odd language of retroactivity for the minister. And then finally, there is one statute that's also impacted, and that's the Municipal Conflict of Interest Act. This is beyond the Municipal Act. There is a new section that only applies to the head of council in a designated strong mayor municipality. As you know, any member of council cannot become part of the decision-making process if they have a pecuniary interest. This is what this section says for the head of council. And it says that the mayor shall disclose the interest, if he has one, as soon as he becomes aware of it by filing a written statement with the clerk. That's important because typically the written statement requirement only now relates to things that happen at meetings. And as I've told you today, some of these things that the mayor is doing do not happen at meetings. Vetoes, directions to staff, those don't happen at meetings. So if the mayor finds out about it, must file a written statement and then cannot use that power or exercise the duty if the mayor has a pecuniary interest. Okay. So as conclusions now, council, for strong mayor powers, there is limited executive powers, authorities, and responsibilities to heads of council, but they're very significant. I've outlined the administrative powers, the / administrative political powers, those three powers that can only be used with respect to prescribe provincial priorities, where a mayor can step in to require a matter to be considered if it potentially advances a provincial priority, require a bylaw to be voted on and possibly enacted with more than 1/3, again, to advance a provincial priority, or to step in and veto a recently enacted bylaw in whole or in part because it it potentially interferes with a provincial priority. Okay, then there are the budget powers or responsibilities, and then all of the miscellaneous powers, duties, and other things that are in the Municipal Act. So with that, Mr. Mayor and members of council, I've come to the end of my presentation proper. I'll stop sharing my screen at this point, but I would be happy to take any questions, Mr. Mayor, that you or the rest of council may have, anything that's remaining.
Okay, we have one here now.
Yeah, okay, so I have one question and well, two actually. Can the mayor veto another legislation? So let's say that he could eliminate a mayor election under the guise of saying he needs to complete this certain housing project. Can he go against the Election Act?
I'll answer the question. You can ask the second one through you, Mr. Mayor. The answer is no. The mayor cannot do that. That would be contrary to the Municipal Elections Act that requires an election for all of council every 4 years. Section 14 of the Municipal Act says you cannot pass a bylaw or anything like a bylaw that conflicts with superior legislation. So that would be directly contrary to what the Municipal Election Act says. And so therefore it wouldn't withstand, it wouldn't hold up.
Okay, and my second question was, for example, now we are 6 councillors at the table plus Mr. Mayor, making us 7. There was discussion in the past for maybe cost issues that we reduce the council to 5 maybe in another term. So if the council is now 6 and then reduced to 5, does that make them no longer eligible for the strong mayor powers?
Through you, Mr. Mayor, the simple answer is no. So, Councillor, you were granted the strong mayor powers on May the 1st. You were done so based on whatever arbitrary decision the province made to say, oh, it's only municipalities with 6 or more members. The fact that a municipality may go in, change its council composition for the next term of council, I don't think will have any effect whatsoever on changing. It certainly won't have an immediate automatic impact because it's not actually a legislative requirement. It's just something that the province picked out of a hat to decide that they were going to give strong mayor powers to additional municipalities. So I don't think it would make any change.
Okay, thank you.
Any other questions? No. All right, well, it seems like there's no other questions here. John, thank you very much for your presentation. It was very informative. I'd already seen your presentation, found it very informative, but it's getting around the whole practice as we know it, so to speak. That's going to be a bit of a trick.
It certainly has been thus far, Mr. Mayor. Well, I thank you for the opportunity to appear before you today. I do hope this was informative. I do appreciate that there was a lot of technical things that I was talking about. I mean, I've been dealing with it now for about almost 3 years and noodling about it, thinking about it. So for me, it's a little bit easier. I have been dealing with a myriad of questions across the province. So let me say this: if I can help you any further going forward, I'm available and I would be happy to do so. In the interim, I wish you all the best, and I thank you again for the opportunity to come here today and speak to your council.
Great, thanks again.
Thank you.
Thank you.
All right, we have a motion to approve the confirmatory bylaw.
By Councilor Dunn, seconded by Councilor Bertrand, that bylaw 4640 being a bylaw to confirm the proceedings of council, be enacted and passed, and the court would still be affixed thereto, and that bylaw be signed by the mayor and clerk.
All in favor? Carried, motion adjourned.
Moved by Councilor McLean, seconded by Councilor Denson, that this meeting be adjourned at 5:36 p.m.
All in favor? Carried. Don't we meet again in 20 minutes? I think there's there'll be food on the other side.